Questions? We have a little bit of time. Yes, sir.
Judge Jones, what effect do you think the Supreme Court's decision to intervene and decided the Bush Gore election had on its reputation?
On the court's reputation?
Yes.
I think that I think it caused some justices. If you read Jeffrey Toobin's book, The Nine, it is a pretty good dissertation on how that ripped the court apart. And Toobin, who I know a little bit, I wrote, I think, a remarkable book and had some pretty good sources within the Supreme Court, including, I think, some justices who felt the need to talk to Toobin, which was pretty remarkable because it usually doesn't happen. You could identify a couple of justices, I think, who were deeply affected by that. Probably one was Sandra Day O'Connor. I think Stephen Breyer was deeply affected, John Paul Stevens. I'm not sure anybody in the Supreme Court was happy to get that case. I think even those who voted with the majority in that narrow decision in the Supreme Court were uneasy and understood that it wasn't going to be good for the court. But it's not the first time that the court has been torn apart by a particular decision, and it won't be the last time. So in its time, I'm not sure that it added luster to the reputation of the Supreme Court, but we have this enduring system, and life goes on, and so they will as well. But you know, it was not. I think most people think that that whole saga from the election through the court's decision was not the finest interval in American history. But you know what's interesting about it, you know, as you look back on the time period, and you know, whatever side you come down on, and I don't want to presume, you know, one way or the other, but no shots were fired. Nobody died in that. People got a result they didn't want on a number of people in the country. But we move on as a country, and I think again, from my perspective as a judge, that the country respected the rule of law and moved on was good. And I commend, for example, Vice President Gore, who probably could have pushed back and done some other things. You know, he had some paths he could have followed even in the face of the Supreme Court decision. And he decided for the good of the country to move on. And I thought that was a patriotic gesture by him at the time, recognizing that there has to be an end point to these things. So we tend to get ourselves into these fixes, and then we tend to get ourselves out of the fixes. But it was not necessarily the finest moment for the Supreme Court, and I think in all candor, the justices who were there at the time would probably tell you that. A lot of questions. Yes, sir.
Your Honor, we were discussing earlier on the importance of the independence of the judiciary. Now, had you been sitting on a Pennsylvania state court and got the same case and made the same ruling, and have to face the voters the following year, there would have been a good chance of removal, as we saw even on the Iowa Supreme Court. My concern is that if judges need to be counter-majoritarian frequently, we cannot ask them to face the voters even at the state level, and it's a terrible corruption of the independence of the judiciary for a sitting state court judge to have to be accountable to the majority.
Right.
It's like trial by popular vote.
Well, I'm concerned about that. We chatted about it before lunch, and I adhere to some initiatives that former Justice O'Connor has been involved in, and that's to take the money out of the process of particularly electing appellate judges at the state level. And we have a real bad record in Pennsylvania, I confess, between our intermediate and our highest court in Pennsylvania, and I think money has polluted and corrupted the system. Some of you who are in the legal realm know of the Caperton decision that came out of West Virginia recently that shows just what can happen. It was life and fiction imitating each other, because John Grisham wrote a book that really was similar to what happened in West Virginia, where it would appear that somebody bought a justice by the campaign contributions they made. So it's a real serious issue, and it's a problem. But it's for states to decide how they want to go about doing things. I understand people who stand up and say in a democracy we ought to be able to vote for judges, but and that's a wonderful concept in the abstract. But when it gets into practical application, I think it's a real problem. I got a laugh out of both of you when I said it before, but I tell you, if we didn't have Article 3 and life appointment, and if I had to stand for retention in certain parts of Pennsylvania, I would have been machine gunned over the case that I say, and others. So it is liberating to know that once you go through the confirmation process, you're there to stay, unless you commit some horrible transgression, but certainly not a decisional misdeed. Yes?
You mentioned fighting the tyranny of the majority, which reminded me of language in the Prop 8 ruling in California. Could you assess your arguments in the Prop 8 ruling?
Well, because that case is on its way to the Supreme Court, that's an area that I shouldn't tread into. The only thing I'll tell you about Prop 8 is that I had an email exchange with the trial judge in that case, it's interesting. You don't realize this till you become a judge. People ask me after the Kitzmiller case, they said, "What did your colleagues think about how you handle that case?" And you might be surprised. We don't get into each other's dockets, and we don't sit around and critique our colleagues' work. We're interested in how long did it take. How did you handle that disruptive courtroom? It's like a bunch of UPS drivers. Did you crack the truck up today? Did everything work out all right? Did you drive into a ditch? Did anything go wrong? And so Judge Wright and I had an email exchange back and forth. Really, I commended him for the way that he conducted the proceedings, which I thought was even-handed and well. And we sort of compared notes, and he was very gracious and said that he was very cognizant of how I conducted the Kitzmiller trial and tried to emulate some of that in conducting the Prop 8 trial. But I ought not give an opinion as to how that's going to end up because it's a pending case. Yes?
Yeah, speaking of the confirmation process, what do you think of what has happened with the confirmation process in the country, and do you have any possible theories of how we can get out of the mess we're in?
Well, it's a blood sport, obviously, now. No, it is, and it's not good. And although I thought Justices Kagan and Sotomayor had a pretty uneventful confirmations, and I'm glad to see that. I'm going to guess that some folks in this room are not fans of Justice Alito, but it's just a guess. But when Sam Alito, I was talking to Barbara about Sam Alito earlier, and agree or disagree with his philosophy or his the decisions that he's rendered. When Sam Alito's wife runs out of the hearing room crying, because they're harpooning him over something that really is beyond the pale, I think we've gone too far. I do, and I think we just have to stop someplace. And I hope for future confirmations they more are in the realm of the Kagan confirmation or the Sotomayor. These are important positions and they should be vetted. I'm not suggesting that we go back because those of you who follow these things know that it was really unprecedented much before the mid-1950s to have nominees appear before the Senate, and usually they were, in a couple weeks or a month they were confirmed, and the vetting process didn't take that long. This has become something that is in the age of the old news cycle, and of course that feeds it too, doesn't it? Because we're in a new age where we have the Fox News and the CNN, and I get on a lot of college campuses, and I tell students, somewhat relatedly, I said, if you're getting your news from one source, shame on you. Shame on you. You know, you should be eclectic consumers of the news. Read a couple newspapers. I realize that they read them online. You know, you sound like a complete fogey when you tell them to read all the newspapers. But you know, I say, you know, don't just watch, you know, Fox News, and you know, sort of concomitantly, don't just watch Keith Olbermann. Don't get it from one place or the other, but be eclectic consumers of the news. But this news cycle that you see feeds this stuff, and I hope for future justices that they don't have to go through what some of the previous justices have gone through. Yes?
I have the hardest time, well, maybe I'm not the only one, with the concept of standing to sue, taxpayers standing to sue, especially when it comes to establishment clause cases or related to establishment clause. Could you speak to that? Like, how does that work, or how do the courts look at her standing to sue?
The only thing I can speak to is it's case by case.
Okay.
They're not easy, but you know, that's the first thing that we look at, obviously, in cases. Then I'm not going to try to lay down a general principle, because you know, you really almost have to look at the bundle of facts involved in each case and make that call. And you can get reversed right away on a bad call on standing, because you know the appellate court's going to look at the same thing. And in many appellate courts, many circuit courts, if they can find a way to dodge making a decision on a standing issue right away, such as the Pledge of Allegiance case, which as you may know, was not decided based on standing, which as I recall, related to the father's relationship with the child and whether he was the custodial parent and so forth. And that's a little different than your question, but standing, you know, is always an issue in every case. But to give you a cookie cutter explanation, we don't use one. We've got to be circumspect and careful in every case that we do.
So there's no underlying principle of...
Not for me. You know, I can't speak for all of my colleagues, obviously, but it is a difficult analysis. And it's one we spend. The best I can do is tell you we spend a lot of time on it in many cases, because it's less than clear as we look at it. Yes.
At least one of the sitting judges on the Supreme Court has been quoted with who knows how much accuracy as to the opinion that the judges should pay greater attention to the majority view of the community. Mm-hmm. You've expressed your view on that. What about the broader legal community? What is their opinion of that kind of view?
I don't think most judges feel that way. I think that there have been arguments made. Scholars have written that as you go through history, sometimes the Supreme Court's decisions tend to sort of presage the prevailing view in the country. And you could take Brown versus Board of Education as one of them. You know, they wanted to impeach the entire Supreme Court when Brown came out. Well, it's sort of second nature now. So the country grew into the mindset that the Supreme Court had maybe in 1954. But I think that's bad judging policy to do that. I thought you were going to ask me to react to a particular sitting Supreme Court justice, and my answer to that always is, I say, you know, technically, John Roberts is my boss. Somebody is taping me right now.
I tried to avoid that.
I could go back to Harrisburg tomorrow and find out I've lost furniture. My chambers has been moved. I've been evicted. Something bad may happen to me. Yes.
If you had the opportunity to speak to President Obama after his remarks during a State of the Union address to the Supreme Court, after Citizens United, what would you have said to him?
I would tell him that I thought he made a mistake. But that said, I had occasion in I'm part of the Third Circuit, and we had a Third Circuit conference earlier this year. And our circuit justice, one justice is assigned to every circuit, is Sam Alito. And that's because he was Souter, but now it's Alito. And Alito was a member of the Third Circuit Court of Appeals, so it's sort of a natural fit for him. And he came back and he spoke to us during one of the lunches at our conference. And it was quite clear, listening to Sam's comments, that he regretted, that he very reflexively responded to what the president did. He was not happy with himself. That was a knee-jerk. That was not that. And I will tell you, I know Sam Alito a bit, and that was way out of character for him. And I'd like to think it was out of character for the president too. I don't know if somebody ginned the president up to do that, you know, or if he got a bad piece of advice. I mean, this is a guy, President Obama, who I have abundant respect for, a great deal of respect for. He's a constitutional scholar. He's a lawyer. He's, you know, he understands the way the world works. I could see other presidents, perhaps who are not lawyers, doing that. But I think, you know, to force that on such a public stage is probably not a good thing. It's a little bit unseemly. I'm okay if the president uses the bully pulpit, you know, to talk about why he disagrees with a particular Supreme Court decision. That's fair game. You know, that's okay. But to call out the justices, I think what you're going to find is it's going to reduce the attendance by the justices at the next State of the Union address, and that's a shame because I think that's a great sort of pageant when you have the three branches of government sitting together. I don't know how the president feels about it, but I'm going to guess that he probably regrets it deep in his heart, as Alito regrets the confrontation. I don't think either of them meant for it to get to that point. Other questions? Yes, sir.
I'm very concerned about a recent decision by the Supreme Court relative to saying essentially that a corporation has the same standing and rights of the individual. And as I compare myself to General Motors,
You're doing better.
Well, if you were General Motors, you'd be owned in part by the Chinese today. Well, you know, I'll tell you, without getting into the nuances in that decision, one of the problems I think that we're having